gì này, đang xử cái trước đó nên chưa có xử cái của mình.
Yes, city's ready.
Bữa nay không đi làm mà chứ mà thứ sáu mà.
All right, I'm now going to convene this special magistrate proceeding. This 6th day of December, 2024, Anno Domini. I guess we're here.
Ms. McKelvin, because we're picking up something somewhere, I just wanted to make sure we have a proper record. So if I could just inquire of it, I know they've been having a little problem as they're doing the upgrades. Inquire of IT, if we're ready in terms of for record purposes. I'm sorry?
We're ready to go.
Okay, very good.
That was the Zoom participant that you heard previously. She's online waiting.
Okay, great, thank you.
Do we have any Zoom participants at this proceeding?
Ms. Tampar, probably, I would presume. She is also a respondent or someone, a representative on her behalf.
All right. Who wants to volunteer to give me a brief summation as to why we're here today?
Judge Clyde, one of the things I was going to discuss is we're here on the notice that was received by Social Daytona Inc., which outlines the violations, the day and the place that they were alleged to have occurred. Again, it's selling alcohol without a license, not an after-hours permit, and I forget what the third one is.
I think those are only 2 violations we said were the no state alcohol license. So sale without alcohol license and the operating without extended after hours without an extended hour permit. Yes.
Sure, understand. All right, so what are we here for today?
They've been cited for those 2 violations, and we're here on a hearing where we're requesting irreparable, reversible, and a proceeding on the matter of the violations. That would be regarding both. Let me pull it forward here. That would be, I'm sorry, regarding both Alvin and Cardin LLC, as well as Social Daytona Inc.
All right, does that mean, all right, hang on one second.
Oh, I need you to go down. At least when you're talking.
You know, I have a cold.
And you can control that.
Hello.
So we're here on the notice of violation dated December 7, 2020. No. We're here on a notice of violation.
The one that they were served with has up in the right-hand corner, 11/15/24. They received it in December.
Okay, I have a notice of violation, appears to be. Okay,
Mr. Couch, I guess if
is this
indeed,
the notice of violation we're here on? Says it's, tells me date of inspection 11/14/2024.
Yes.
yes.
Okay. Notice of violation. So this is a notice of violation. And I have a petition for rule to show cause. I assume that's to be addressed today as well?
No, it's entirely up to you if you address it at all. But it doesn't need to be addressed preliminarily.
All right, so. And as I understand the materials I've read, this notice of violation involves a number of different events occurring circa October of 2024. Is that about right?
Yes, that's correct.
But not
Okay.
according to the notice that I've got.
No,
Notice I have says that it occurred on November 15th, 2024.
All right, I'm assuming that's the last of the events that were,
right, there were two sets of events. Yes, that's correct.
okay.
And that was the only one that they,
Is that not correct?
Daytona Social received, or
That is
social.
when they were first notified of the violations occurred.
You can speak to that. The magistrate.
You know, Mark Jones, code compliance.
You swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes,
Thank you.
the violations both occurred in October. One was on October 19th and one was on October 26th.
I've seen
they-
the incident reports.
Okay, they received their formal notice of hearing is what, on the 15th.
Gotcha. All right. So the notice of violation we're here on today involves the two charges we've already identified: sale of alcoholic beverages and operation beyond extended hours. And while the respondents may have been first notified on November 15 of 2024, what we're here to talk about are the events of October 19th and October 26th. Did I say that right?
Yes, sir.
Okay, well, I've already read those materials.
Ms. I'm sorry. Yes, Mr. McKelvey, before we proceed, I know we have the other respondent on hold on Zoom, and I think they should be, I guess, present and participant in anything we're doing going forward, since they are responding in the proceeding, unless you plan to bifurcate it and handle them
Okay,
separately.
so this is Ms. Tam, I assume?
Oh, she is there, okay.
Yes.
All right,
Hello, Magistrate.
Ma'am, can you state your name for the record?
My name is Tammy Tran.
Do you swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
Yes.
Thank you.
Thank you.
all right. Well, let me back up again. I have previously fined the owner respondent the sum of $1,000 for two events,
That's correct.
and I fined her $500 per event.
That's correct, sir.
I previously fined the tenant respondent the $15,000 sum for what was something irretrievably broken or something like that. What's the language?
Irreparable, irreversible.
There you go. Okay. All right. Do those, what if any bearing, I'll ask you first, then I'll ask him. What if any bearing do those fines have on what would appear to be a garden variety notice of violation that I'm getting ready to address as though I'm starting from scratch?
Well, in one sense, well, let me say it this way, none.
Okay.
It,
What say you?
None.
Okay. All right. So then we're basically starting from scratch here.
yes, there may be some argument of repeat, but
I
we're
understand.
looking
I
for
understand.
irreparable, reversible.
Between all the investigative reports and all the minutes I've read, I think I got a pretty fair understanding. Now, Ms. Tran has been here
Yes.
in the past with Mr. Vagovic. Is she not represented today?
No, he's not here today with me. I'm on by myself.
Okay, fair enough.
I've
All
been
right,
informed
then
that
let
he
me,
know.
before we go any further, when I last looked at these materials, your eviction proceedings were underway. What is the status of those eviction proceedings?
Mr. Vakovic has dropped the case because of the last case for the tenant has not asphalt. So the case for eviction has closed.
Okay,
Yes, I have a copy of the voluntary dismissal.
a voluntary dismissal?
Yeah.
Why was your eviction proceeding voluntarily dismissed?
From what Mr. Vakovic told me,
I don't have.
I'm not clear, to be honest. He might not feel comfortable because he told me that since the case is not the case for the tenant violation has dropped, so he told me it's better to do like another tenant and landlord meeting. So we just did that few weeks ago. And I'm on the process of asking the tenant to pay his previous rent, but he has not responded to that yet. So we did the 3-day notice again. And we might have to do another eviction, but this time is not for the case. It's nothing relate to the case. It's more relate to the rent.
And just for the record, the board secretary has provided you a copy of the notice of voluntary dismissal for, and we'd like to make that part of the record as I've received it from Mr. Lambert. My best understanding was that Mr.
Just a
Vakovic,
second.
I'm sorry, thank you.
I trust you recall the fine that was imposed upon you was reduced considerably from what was being requested because you were in the process of evicting what you considered and described to be a problematic tenant. So now you're telling me you have voluntarily dismissed that eviction proceeding?
Mr. Magistrate, this is not my decision at all. Is Mr. Vakovic say that it's best that I dismiss? I didn't even know that when he dismissed, that means the eviction has dropped. At that time, he only told me that this is the best way to do is to have another meeting with the tenant. He has nothing telling me that the eviction will be dropped. That's why I changed another attorney because I don't know. I don't feel comfortable with the way that how this
Who's your current
leading.
attorney?
Mr. Slick,
Mr. Who?
Slick Michael.
Okay. And how long has he been representing you now?
Couple weeks now, and he is more about eviction than Mr. Vakovic, I would say. He also the one who wrote the lease. But at that time, Mr. Vakovic, back in July, Mr. Vakovic has advised me the best option is to do another meeting with the tenant, landlord tenant meeting. I would not aware that he dropped the eviction. But it's a pass. So, but he said that's the best solution. Yeah, Mr. Magistrate.
Okay. All right. Well, we have a notice of violation directed to two respondents, one being an owner, one being a tenant. Let me go to Ms. Tran first. Do you agree this violation existed or occurred as stated in the notice of violation?
Yes.
And as to the owner, I find the respondent in noncompliance. As to the tenant, Mr. Lambert, do you agree this violation existed or occurred as stated in the notice of violation?
No, and can I show
Okay.
you the notice of violation that we received?
Pardon?
Can I show you the notice of
Sure.
violation that we received? And also, my recollection of the last hearing was that the owner was not fined because of the eviction proceeding. The court's admonishment that you better follow through with this or else.
That was my recollection as well. Okay, I've seen this. You can have that. All right, so we have an owner who has basically conceded noncompliance. We have a tenant who is disputing noncompliance. And so that having been said, and the preliminary indication was we're starting from scratch as far as this particular proceeding is concerned. So that having been said, let's hear what the city has to say with regard to its evidence of noncompliance.
Right, the city's ready to proceed, and the city would call Mark Jones to initiate the proceeding.
Okay.
She's not seeing or hearing anything at the moment. The system went down, so.
Okay. All right, folks, stand down for just a moment if you would. All right, folks, we're back on. Just a second, Mr. Inspector. I have another question for the attorneys. With regard to my order imposing the fines that were imposed both as to the owner and to the tenant, was there any judicial review of that order, or is there any such judicial review pending?
Yes,
Okay, what's the nature of that?
appeal,
Okay, and what's the status of that?
limbo.
Okay, so it hasn't been determined yet.
No.
So as far as this tribunal is concerned, that order is still out there and in effect.
Yes, yeah, that's correct.
Hasn't been overturned, hasn't been compromised in any way at present.
Yes, and we're talking about your most recent, your last order,
Right.
not the one that's
I
when
was
she was
just wondering
fined
if there are any
$1,000.
judicial developments I needed to be aware of
Right.
before we proceeded. Okay, all right. Thank you.
Again, Mark Jones, Field Supervisor with the Code Division, City of Daytona Beach. This case was opened after a police undercover investigation, the violations of the City Code Ordinance, Section 6.21 for a business serving alcohol without a state license, and a violation of the Land Development Code, Section 10-3 for business serving alcohol after 12 a.m. without an extended permit issued by the City of Daytona. The city has received ongoing complaints for this business serving alcohol without a state liquor license and operating without an extended hours permit. On October 19, 2024, and again on October 26, 2024, two undercover police officers went to Social Daytona located at 631 North Grandview at approximately 1 a.m. The entrance charge was $100 for a male and $50 for a female for a one-night membership fee good till 5 a.m. that included alcoholic beverages. The violation notice for irreversible was sent to the property owner and their registered agent, and to Social Daytona and their registered agent. The notice was posted on November 15th, 2024. This action is irreversible in nature. Staff recommends a fine of $15,000 to the owner, Ivan and Cardin, and a fine of $15,000 to Social Daytona for these violations. There are police officers present that can provide further details.
All right, what if any role did you have in any of these undercover operations?
I did not have any role.
All right, and what if any experience do you have with these properties?
This has been a continuing challenge for code enforcement. I believe we've been before the special magistrate at least 3 times in regards to these issues.
And these issues you're referring to are the alcohol sales without a license
Yes,
and operating without the permit.
correct.
Okay.
Excuse me, sir, we did not cite them for not having a liquor license, state liquor license. We did cite them for being open after hours, serving alcohol after 12 p.m. without a permit, extended hours permit.
So have you or any of the other inspectors been there after hours?
No,
to
sir.
confirm for yourselves?
No, sir.
So the testimony that we're going to be relying upon as far as the city is concerned comes from the officers exclusively?
Yes, sir.
Okay. So you're here to kind of summarize procedurally where we stand at present?
Yes, sir.
Okay. Counselor, do you have any questions for him?
No, sir.
No, I don't have any questions.
Okay, Counselor, do you have any questions for
No,
me?
sir.
Okay, thank you.
Thank you.
City will call Lieutenant Gernert.
Okay.
And Judge, before she testifies, can I go to her?
Sure.
Was she put under oath? I don't.
I do.
Would you please state your full name?
Kimberly Gernert.
And these operations that Mr. Jones, excuse me, was just talking about, were they all video recorded?
Yes, yes, sir.
And those video recordings are within the sole care, custody, and control of the Daytona Beach Police Department.
Yes.
In fact, not you,
Mhm.
but members of the Daytona Beach Police Department took the entire surveillance system that belonged to Social Daytona and have that as well.
We do. It was seized under a search warrant.
But you have all of that,
We
that
do.
evidence.
Yes, we're still in possession of it.
Okay.
It's being processed.
Okay. And is that axons are immediately available, are they not?
Public records requests are yes. And then if it's during a criminal proceeding, it would be through discovery, I'm assuming.
What about for a hearing like this? Is the magistrate not permitted to see the best evidence?
I don't see why not.
That would be a judge, that the best evidence would be the video recording.
Video recordings of what?
I'm sorry, go ahead.
No, I'm sorry, you.
Video recordings of what?
We use an undercover technology to record the undercover event of the purchase of alcohol from the business, from the owners of the property.
So does that mean your undercover officers are actually cameraed up to where what I would be looking at, were they to be played, would be the interior activities there at Social Daytona?
It would, however, I would request that I can't, I don't want to reveal their identity, and I can't
Okay,
distort
I'm
their.
not asking you to, I just want to
Okay.
know what the videos would.
The video
depict.
would show them approaching the business, speaking with the owners, purchasing alcohol, consuming the alcohol, and then leaving.
Okay. Are these officers here to testify this morning?
No, sir, just me. Through the technology that was utilized, it's run through an app. I watch it in real time, not far away. It's within seconds of the recording. So I witnessed it from beginning to end.
Two things, Judge. One, when they wear these apparatuses, it doesn't show their face, it shows what they're seeing. And two, it is the best evidence, and the case law is, I know it doesn't apply here, but case law is clear that someone doesn't get to say what an image they saw purports when the image exists. So that the image is the best evidence, not her commentary on that.
If I may, Mr. Vakelja, in an administrative proceeding, one, the former rules of evidence do not apply. The standards for production of the evidence is substantial competent evidence following the essential requirements of law. These are, and here's evidence is admissible. Yes, there is a level of evidentiary review that would make this proof beyond a reasonable doubt. And having that best evidence, as Mr. Lambert is alluding to, would be more towards the weight of that evidence, not for whether or not it's evidentiary truth based on the testimony of a person with substantial competence, such as the lieutenant who saw at the time of these things occurring. Her testimony would and should be sufficient for this type of proceeding.
You know, I mean, no insult whatsoever to the lieutenant. But we got three lawyers here who were raised under the umbrella of the best evidence rule. I don't know why you are having to try to explain to me how the lowest common denominator of evidence, and again, I'm not trying to be insulting, but when I have a supervising officer telling me what she saw other officers do and what is actually depicted on a video that's available to be viewed, that bothers me. And so, again, I'm struggling not to be insulting, so please don't. It's just the technician in me. You are literally arguing for the lowest common denominator of evidence that the city intends to present when there is best, better, probably undisputable evidence that's available, but not being presented.
I don't necessarily agree that that's true, Mr. McKelger. The view of a axon video for one individual doesn't tell a picture of everything that's going on, which is what she's seeing and
You know,
hearing.
you're having a hard time here because I see police videos all the time and they're very explanatory as far as I'm concerned. And I'm capable of putting things in context.
The magistrate is well able and we're well willing to bring those axons with, obviously with the proper redactions where
See,
necessary.
because another inference that you're going to be subjected to here, and I'm just going to be perfectly honest with you, is if this evidence is available and could be very well displayed. Heck, I got Mrs. Tran in here from Texas. Then it creates the inference that maybe the best evidence doesn't depict what we're being told it depicts. And maybe the best evidence is actually going to contradict the testimony that's being presented.
We are presenting.
Because I suspect that's what Mr. Lambert's going to argue.
We are presenting video and photographic evidence. We just have not presented or had the intent to present the axon evidence. Axon evidence is not very
Well, here,
difficult
I'm going to make it simple for you here. You can proceed with whatever you plan on proceeding today, and I will make a determination on the basis of the evidence that's been presented. Or you can defer this matter to another day for the sake of presenting anything that you perhaps don't have available with you today. Did you hear me?
I'm sorry, not completely.
I said, we can proceed this morning and I will make a ruling on the basis of whatever evidence you present. Or if you choose to present other evidence that perhaps is not available right this moment, then I will continue this until you have it available to present. I'll give that option to you. What do you want to do?
If I can have 5 minutes to speak with my officer, or
Absolutely.
probably 3 minutes would be enough.
I mean, this is a significant fine. We're here again. This is a significant matter. And let me emphasize something to you. If I'm satisfied there's illegal alcohol sales going on, and I'm satisfied that they're operating beyond extended hours, I won't hesitate to fine them. What troubles me, though, when I do something like that, is to know that there's other evidence out there that's not being made available for one reason or another. And I'm pretty certain a compelling argument can be made that that evidence would be probably dispositive. But in any event,
Understood.
talk to whoever you want to talk to.
Thank you.
Are we in recess right now or something to that effect? Okay. Hi, Hannah. Okay. Not a problem. Y'all sit up now? All right. Not a problem. Seen Mr. Gambert lately?
I have not because I have a cold and I don't want to add anything, but I understand that he's requested no flowers but jelly beans.
I sat with him Saturday night. Spo and Dugan and I went and watched the ball game with him.
So do you come in?
Well, he came in just for the evening to visit, but he's a mess.
Bill is. Has he been able to find somebody to watch him at night for 2 hours?
I don't know. I know he's got somebody driving him around now
Yeah.
to his dialysis. And it sounds as though he's either going to be moving to either Sarasota or Mobile.
I thought he put his foot down on that.
Pardon?
I thought he put his foot down on that and said, no, I'm staying here.
I think he's come to the realization it's, pardon? Okay. Okay, thank you. I think he's come to the realization that's not right. That's not possible.
This is the place this is the only place he does people. I mean, Sarasota, obviously, we continue to practice a lot. Oh, yeah.
Wow, this is a fancy new microphone. Excuse me. All right, have we resumed?
Yeah, we're ready to resume, Mr. McKelvin. The position of the city is we're able to pull the axon off of the cloud or whatever it is, evidence, and we're willing to present it as we kind of agree somewhat that it probably would be dispositive, and so we're more than willing to share that. And even at the cost of maybe losing the opportunity to utilize our undercover, but we are
Losing what
willing
opportunity?
to utilize our undercover to whatever extent that
You're not
that
gonna
affects
lose
us.
any, I mean, you can redact, you can do whatever you need to do to protect your officers' identities. I'm not the least bit interested in them. You can modify their voices. I don't care what you do in that regard. You know, what I'm here to look at is to see what this respondent did. I'm more interested in the activities of the respondent. So, and I'm not trying to, you know, if you're telling me it's impractical and it can't be done without disclosing these identities, then so be it. Then as far as I'm concerned, that evidence is unavailable. And I would consider it unavailable. You know, if however, it is something that can be displayed without disclosing any of those identities or any of the police department's procedures or any of the other things that are considered secretive and confidential, if it can be done without doing any of that, okay, yeah, I'd like to see it. If it can't, then I will consider it unavailable. And then I will not be ascribing any inferences one way or another to its presence or absence. Then it will truly be just a matter of testimony.
Okay,
So I'm not trying to create an impossible situation here. I'm just wanting to satisfy myself that there isn't more compelling evidence out there that's reasonably available to be displayed that could impact the outcome of this proceeding without jeopardizing confidentiality or anything of that nature. So that having been said, what do you want to do?
Okay, well, you raised something that I don't know if we actually thought of and may need an inquiry of the IT to determine. Is that you want to go move forward and play the video? So that's what we want to do. We will go and proceed by presenting the videos this
Okay,
evidence.
so are we doing that today or another time?
Today,
All right.
and as directed by, I guess, Sergeant Blowers.
So it'll play overhead on these.
IT, can you see my computer for? Hold on 1 second.
One other thing, I'll ask if we, at least from the city side, if we can be generally sworn. I think we keep bringing up folks and
Well, in another matter, how long is this video? Because as
It's
far as
about-
I'm concerned, if you want to just play excerpts, that's fine with me.
there's more knowledge of that from my,
It's about 30 minutes.
Okay.
what's the thought of the excerpts of these?
We'll play the beginning of the video.
Okay, and again, if there's any kind of possible narrative or response to any questions, Mr. Blowers, Officer Sergeant Blowers, you need to be sworn as well. I just need y'all generally sworn. Okay, go ahead and get sworn before you get going.
Do you want to just do everybody who possibly might be testifying or just Blowers? Anybody else?
If you could stand as well.
Yeah. You swear or affirm the testimony you're about to provide is the truth, the whole truth, nothing but the truth?
I do.
Thank you.
Okay. Now you may proceed.
Okay, for the record, what is it that I'm getting ready to see?
So.
This is Lieutenant Gennard, is that
Gernert,
correct?
yes, sir. So the video is going to start with the undercovers walking towards the front of the business. They are going to
Okay,
approach.
this is a video that was prepared and obtained by the city of Daytona Beach during
Correct.
the evening in question. This video has been in the city's possession, custody, and control, and is considered to be a business record of the city.
Yes.
Very good. Counselor, did you want to voir dire regarding the authenticity of the video? All right, we're good to go.
We have to lower the volume. Or
Do you have
push
volume?
pause it. Push pause. Play.
Joe, if, what we found in our system is we have to use the cone, whatever that is, for the videos, and the Microsoft and the other ones, we don't get volume. But if we use the that safety cone, I don't know what program it is.
Mhm. It's October 19th.
October 19th. It's gonna be the video of October 19th.
Yes, sir.
And Joe, do you understand what I'm saying?
No, sir.
It's VLC.
Oh, thank you. Need a tech person.
I don't have any control over the laptop volume.
So, yeah,
It's all
get it.
100% on the
Okay.
volume.
I don't believe it's coming through.
It is not.
VLC
pause.
basically.
Well, in the meantime, this is the front of their business that they're approaching right now. They have it roped like you would to go into a movie theater or a club. The front is, has like a front porch
Mhm.
area, and then there's a single door to go in from the middle.
And I believe Ms. Vakel, you asked the length, and I think you already said that about a 30 minutes or so. I guess it shows it at this point.
There you go.
Can you turn it up some?
Is that max?
That's on his max. So at this point, they go and sit down. I can show the rest of the video if you want. It's another 20 something minutes worth, but they sit down and consume their drinks and then leave.
Okay.
But that's up to you if you want to continue to watch
All
it.
right, so why don't you give me a summation as to what I've seen so far?
So the two undercover officers approached the business with the undercover technology. They approached the front door where Mr. Kumar is there requesting their IDs, tells them it's $20 each to get in, but they have to pay for their own alcohol. So she inquires about the membership because on the window, it states members only. So Mr. Kumar explains the membership to them is $100 for males, $50 for females. Alcohol is covered under that fee from 2 a.m. to 5 a.m.
And you're here when this is being made.
I am across the street,
And what time of night was this?
1:30 in the morning.
Okay,
So they get explained what the membership covers. They decide to purchase the membership of $100 for males, $50 for females. They get a stamp on the back of their hand, just like they would if they went to Razzles or 509 or any other club. They enter the business, go right to the bar. The third owner of the business, Mr. Dayukar, is behind the bar, asks them
is
what.
that the heavy set guy?
Behind the bar, yes, sir. Asks them what they want. They order, they ask him, what do they have, as in what alcohol is present. He tells them vodka, rum, tequila. They order a Patron, no ice, and a whiskey, no ice. They take the drinks and they end up going and sitting down for a little bit, consume the alcohol, take a sample, and then eventually leave after about another 15, 20 more minutes.
Anything else?
I utilized a portable breath test prior to them going out on the operation. They yielded a,
Again, I would object, the best evidence would be the result. It prints it.
Go on.
it does not print, but it yielded a 0.000 reading at the beginning. None of them had any alcohol on them. None of them actually carried anything but their IDs and the money. Afterwards, when they returned to the starting point, I gave them another portable breath test. The first reading was for the male undercover detective was a 0.04, which is half the legal limit, and a 0.02 for the female. At that point, they went on about their business, and then I conducted a second operation very similarly using the same two undercover detectives on October 26th, right about the same time. They approached the business just like they did in this video, spoke to Mr. Kumar. They were offered to pay, they had to pay another $100 male, $50 female, but the female detective asked about the prior 2 weeks membership payment, and that they said it was only for that night, for the 19th. Again, went to the bar, and a different employee served them the alcohol that they ordered, but they ordered again a Patron and a whiskey. They took samples of that alcohol, brought it back to me at the end. They were portable breath tests in the beginning of that operation, all yielded 0.000. And at the end, they had a 0.114 and a 0.20, I believe. I have to look at my record, but they definitely had consumed alcohol from the operation that they ordered.
Whatever came of the vials that were taken,
The vials were taken as evidence and submitted into evidence at the police department by me.
were they ever tested?
We did not test it, no.
All right. Do you have any questions?
I did. When the undercover officers went in, they were talking about a menu and a flyer.
Yes,
Did they ever grab the flyer and bring
No.
it? Did you ever see the flyer?
just through the camera at the time it was being read.
You know, it says on there that everything is it doesn't have any alcohol in it.
That's not how she read it, but I didn't hear her say that if it was a non-alcoholic.
And the breath test that you say you administered, it's a portable one,
Correct.
so it's photographable.
I have it present, and yes, we photographed it.
Okay.
You have what present?
The portable breath test.
You have it here?
I do.
Okay.
It's real small.
And you indicated that they went in with vials
They did, yes.
and went into, I think they went into the restroom.
The first time, no, but the second time, yes.
So the only time there would be any evidence would be the second time? I mean,
No, there's evidence in the first one. The female poured it from the bar into the vial.
Okay,
On the second one, they individually went to the restroom and poured a sample into the vial. The one that would be recorded would be with the female.
And these vials that came back and are evidence, were they put in evidence at the Daytona Beach Police Department?
Yes, sir.
And are they of an alleged alcoholic nature?
Yes.
And were they put in a refrigerator?
I tagged them as proper evidence. I don't know what the clerks do at that point. I'm not sure if they refrigerate it or not.
Is that something new with the Daytona Beach Police Department, being able to take files?
Yes, we previously, we weren't able to take liquid. It's not something we were able to tag into evidence. Not sure what changed about it, but we are able to take liquids and tag them.
You said they have not been tested.
The department did not test them, no.
When did you put them in evidence?
I would have put them in there on October 19th at the end of that operation, and again on October 26th at the end of that operation.
And when you do that, do you make a record of it?
Yes. If I may, these two operations led to a fourth search warrant executed in the business where we did find alcohol.
Okay, I'm just gonna show you a document that I have and just ask if you recognize it.
It looks like a supplement.
And who is it authored by?
Me?
And is it sworn to by you?
Yes. Or no, yeah, I swear to it when I sign it.
And what's the date on it?
This one is for, this says November 6th. This is not from the operations. This is from the search warrant.
So in the search warrant,
We took a sample of alcohol in an open container. Because the arrested person is Mr. Jacob.
um, how many of those samples will you say that you took?
We took one from the 19th, two from the 26th, and two from the search warrant.
When was the search warrant executed?
November
6th,
9th.
I'm sorry, 9th.
So that is not an event that's part of this notice of violation?
I don't think that's what was included. I think it was just the two undercover operations. But I'm not the one that cites, so I don't know.
Yeah,
Let
the
me ask
answer's
you
no.
this. Look at that document again. You executed the search warrant on November the 9th.
9th,
What's the date of that document?
November 6th. So then this would have been done as a supplement to where's the case number, the original case number for this particular one is from the October 26th operation, the case number 240015858. That is from the operation on October 26th.
So my question to you before was that it indicates,
So I tagged this evidence on October 26th. If I completed the supplement on the 6th of November, that's why that date would have been there. Not because I submitted it on the 6th of November. It's because it was a running supplement that I had going in the computer.
and I think previously you said that what I showed you was from the search warrant. The sample you took at the.
We
search
took a
warrant.
sample from the search warrant. Yes, there was an open container.
Right, and that was the.
We do have a sample from the search warrant, yes.
Is that evidence of that?
It would be evidence during the search warrant that there was alcohol present on the
My
property.
question is, this one is dated and sworn to you on November the
Right.
6th.
Understand what I'm
So-
saying? Yes, I may have said that. Looking at it, knowing the date of the search warrant, this would have been from the running supplement from the original operation on October 26th. I would have submitted the supplement on that date, but I did tag the evidence on the 26th.
Mr. McKelvey, if I can just, and I'll say it's an objection, but point out that this is kind of beyond the scope since it was not part of the notice of violation. I mean, I realize it's submitted and we'll be happy for you to consider it if you so elect, but we're really going into an area beyond. I think we had already initiated the case in terms of everything they were putting together prior to that date.
Didn't I just hear you say some of this evidence was drawn on October 26th?
The male and the female,
Obtained.
it was obtained by the undercover detectives on October 26th during the operation, turned over to me, and I tagged it immediately on my way out.
And then how does it find its way into this material that he's talking about?
This is a supplement to the report from the original supplement,
to the
correct?
Original 26th
Correct.
incident report.
That is the correct.
Okay, and so this supplement, what, addresses evidence you obtained on October 26th?
Correct.
Okay,
It just documents that I tagged evidence. The
Okay.
dates are there's a discrepancy in the dates, of course. It's not because the computer's wrong. It's because when I submitted this supplement, it would have been done on the 6th of November. That's all.
And being familiar with supplements, they actually have supplement on them, don't they?
What do you mean?
When you do a supplement report, it says supplement.
At the top, sure.
Where does that say supplement?
This says affidavit.
I didn't ask you that. I know you swore to it
Mhm.
on November the 6th, with nothing else indicating October on there,
Okay,
and nothing indicating supplement on there.
okay.
Is that correct?
It says affidavit at the top.
Right. And it says vial of alcohol, property evidence,
Mhm.
November 6th.
Correct. I don't know why it says November 6th.
How about this one?
This says affidavit. It's on Mr. Dayukar for a vial of alcohol on November 6th. I can't answer you why it says on November 6th then, because if this is, if this is for the arrest, oh, I know why. Because I started their affidavits on the 6th in preparation for the arrest on the search warrant on the 9th. That's why it says the 6th. I wrote up the affidavits based on the videos that they were going to be arrested for those violations from those arrests, from those operations. That's why it says the 6th. So that I didn't have to stand there all night and write the affidavit. I did it in advance.
So in October, you wrote November in advance in preparation for an event that was going to occur on November 9th.
In November,
Mhm.
I started their arrest affidavits in the system
Mhm.
for the events that occurred on the 19th of October and then the events that occurred on October 26th. So when we executed the search warrant and made the arrests during the search warrant, the affidavits were prepared and started. And the only thing I had to add at the end would be whatever was discovered in the events of the search warrant.
As executed in November.
Correct, on the 9th.
Let me show you this document. Is that the affidavit you'd be talking about?
Yes,
And what date is that sworn to? on?
that says the 6th
Okay.
because it was started on the 6th.
Okay, so you swore to it when it was started.
The system puts that date on it. I don't know why it doesn't put the 9th on there when it was signed and shipped to the jail. But the system will tell you, when you look at the way the documents roll through the system, it will put it on there as the 9th. It says the 6th here because I started it on the 6th. I
Okay.
signed it and shipped them to the jail on November 9th.
Okay, so from here on out, from the Daytona Beach Police Department, we should not rely on the sworn part of the affidavit.
So if we were to do a long-term investigation and I started a document for an arrest, it's gonna start with that date, whatever date you started and opened up the document. So if we don't do that until another month later, it's not gonna be wrong because all the events are documented. The system just puts the date on there because that's when I opened the document and started it.
Okay, but it says that you swore to it on that date, and the person that put you under oath says you swore to it on that date.
I understand what you're saying, but this isn't, I can't control how the system operates.
But the stroke of a pen could.
I can't change that date because I started it on the 6th and I executed it on the 9th.
And in there, what's dated that you swore to on the 6th are comments about the 9th.
There
correct?
are, at the bottom, there is a paragraph where I talk about the execution of the lawfully executed search warrant, and during the search warrant, the defendant attempted to run from law enforcement
Right,
upon
but
approach.
I wasn't asking you that.
Mhm.
I said that. it
I would have,
indicates-
I would have added it on the 9th,
Okay, and even though it says it's sworn to on the 6th.
correct.
And this particular affidavit states that on the 25th of October, 2024, did the computer do that as well?
No, that's probably just a clerical mistake by me.
So we got a machine that's always going to make a mistake,
Mhm,
and then there's the potential that there be
mhm,
clerical errors throughout.
mhm.
Is there an ability that you know of to test the vials at the Daytona Beach Police Department?
We would probably have to send it out to a lab to have it tested.
Did you ever seize on the 9th any of the bottles that are reflected in the video and that the officer said that he or she got a drink from?
The ones that are on the video displayed on the wall or behind the counter?
Whatever, it appears that somebody is at a counter
Correct,
and orders something
correct.
and a bottle appears
Mhm.
and something is poured into it. When you served the search warrant, did you obtain any of those bottles from that area of the bar or any area of the bar?
There was some twisted tea, I think, nearby, and some of the bottles underneath the counter in the cabinet area that is where it appears they pull the alcohol from. The detectives that looked in there, some of those bottles say spiritless alcohol, but they didn't take a sample from that.
So the bottles that, when you served the search warrant, that were observed said spiritless alcohol?
Yes.
And that's from
And it's
the,
possible that's what those bottles were on the 26th and the 19th, but what those officers were served was not spiritless alcohol because their breath test showed they had alcohol in their system,
that they got alcohol from somewhere,
that they got alcohol from that business.
from somewhere.
Okay,
And they went in with vials.
correct. Empty vials.
Is that recorded
Is what recorded?
when you give them the empty vials?
No. The vials come from our property and evidence section.
Now, the twisted tea that you found,
Mhm.
is that like one of those cans that you buy in a store?
Yes, I believe so.
And they found one of those?
I believe they found at least one. Yes, I know at least one. It was in,
Okay, you talking about something that was found in November?
yes, during the search
I'm
warrant, sir.
interested.
Okay.
I don't have anything further.
Humor me and recreate the exchange that I saw that took place at the bar
Okay.
between your undercover officers and the heavy set guy. Because I was listening as best I could and I thought I heard stuff.
Okay.
So you tell me what it was I heard.
So when Mr. Dayukar approaches them
I
at the
do
bar,
recall mention of alcohol.
yes, the female detective asks, what do they have? He says they have rum, tequila, vodka. And she asks, do they have Patron? He says, Yes, I have Patron and I can't remember the other brand name of tequila that they had. She ordered,
But my point, you're hearing him say this.
yes, he says
And
this.
If I've got a better ear and I'm holding it up against that video, that's what I'm going to hear.
Yes, sir.
Okay. Did you want to inquire about that?
Yes. In that you prepared the affidavit from those dates, is there anywhere in your affidavit that it mentions anything about a Patron or any particular type of alcohol?
My supplement would have that information in it. It might not have it in the arrest affidavit.
What supplement are you referring to? You're talking about the incident reports?
Yes,
Okay. It does.
It has a Patron in it,
Mentions Patron, mentions Jack Daniels.
not in anything that I have, but
I believe Mr. Lambert asked for best evidence. We had
I did.
video.
yeah,
the undercovers also completed supplements at the conclusion of both of the operations. They didn't complete it that night. They completed it when they returned to work the following week. I'm not sure if it was supplied for this hearing or not, but their supplements describe what they did and what they ordered and what they tasted and how it affected them, as they have had experience consuming alcohol in the past.
Very good. Anything more?
No, sir.
Mr. City Attorney, anything more?
We previously presented this evidence, may not be necessary for the magistrate as to their licensing and those types of things, or their lack thereof. I do have the project manager for permits and licensing that would be issuing the
Well, I assume
Business
if
tax.
Mr. Lambert had an alcoholic beverage license, he'd be waving it around right now. And I don't see him doing that. Is that what you're talking about?
Yes, and so that's what she will be testifying to if she were to testify.
That's fine. And, okay, anything else?
And although they have a receipt to be a club, they don't meet the club standards, which is not what they were charged on, but they don't meet the club requirements. So those are the anticipated testimony of this witness. If you want to hear from her, I would bring her forward. I know we previously presented this in the prior proceedings.
And what exactly have you proffered with regard to the notion that they were in operation after 2 a.m.?
After 2 a.m.?
Isn't that the after hours portion of this?
No, without a permit, you can't be in operation
No
after
extended
midnight.
hours permit.
Yeah, without an extended hours permit, you can't be in there after midnight. If they had an
After
extended
when now?
hours,
After midnight.
that's correct.
Okay, and you were there at 1:30.
1:30 in the morning. Mhm.
If they had an
Right,
extended
that
hours
answers-
permit,
that
it would be a
answers
different
that.
time.
Anything more?
I can't think of anything else. No.
Counselor, you got any witnesses you want to call?
No, if I could have a second.
Sure.
My understanding was that when you say we're going to start from the beginning, so we're just limited to October.
I have two events in front of me, October 19th and 26th, if I'm not mistaken.
Yes, sir.
And those are the two events that are subsumed within the notice of violation that's in front of me.
Yes, thank you for the delay. We don't have any evidence.
All right. Thank you, officer,
You're welcome.
and thank you for the video. All right, what say the city? I guess I want to hear something akin to a closing argument on the alcoholic beverage violation and the extended hours violation. So I think I have a pretty fair idea of what's going on. And I think we have plenty of evidence before the special magistrate. So if you just wanted to take a couple of minutes to summarize it all for me, go for it.
Yes, Mr. Vakelja, as the evidence is shown, this is an establishment. I'll present to you all, and I previously presented section 1-10 of the city's code of ordinances as relates to alcoholic beverages. And I think that one to Mr. Lambert, but that ordinance says that an establishment dealing in alcoholic beverages means any business or commercial establishment, whether open to the public or at large, or where interest is limited by a cover charge or membership requirement. And it goes on, including those licensed that I've highlighted. And if I can present this to you, as I presented to Mr. Lambert.
Familiar with it?
I'm sorry?
Familiar with it?
Okay, well,
And
it includes social,
materials.
certainly includes social, fraternal, or similar organizations where a product or article is sold, dispensed, served, or provided with the knowledge, actual or implied, that the product or article will be or is intended to be mixed, combined with, or drunk in connection or combination with an alcoholic beverage or on the premises of such business as commercial establishment or business or commercial established where the consumption of alcoholic beverage is permitted. So in this situation, in this circumstance, it's not an establishment where was permitted, but nevertheless, it is an establishment where by its definition of it's an establishment dealing in alcoholic beverages. And so as an establishment dealing in alcoholic beverages, there's a requirement under Article Section 10-3, and Section 10-3 says that provides hours of operation, except as provided in Section B of this section. No establishment dealing in alcoholic beverages shall be open for business, sell or permit alcoholic beverages to be sold or consumed on the premises, or allow persons except on-duty employees of the establishment to enter or remain within the establishment except during the hours from 7 a.m. until 12 a.m. midnight. Such restrictions are applicable to owners, operators, and managers of such establishment and their employees, contractors, and agents. And that's pretty much based upon the requirements under Chapter 562 of the Florida statute, which limits the sale of alcohol to midnight unless there's an ordinance that provides otherwise. Our ordinance that provides otherwise is our after-hours permit. They did not have one. Because they did not have one, they would be in violation of that code. A violation in that code is a code, city code violation of the subsection 9 of that same section, 10-3. And that says code violations, it shall be a code violation to violate any of the permit requirements of the chapter, in addition to other enforcement actions authorized by the chapter. Code violations under this chapter may be presented to the Code Enforcement Board for prosecution. And of course, as we know under Chapter 162, Code Enforcement Board and Special Magistrate is interchangeable.
Let me see that definition, the first definition you gave me of the sale of alcoholic beverages. There was some language in there.
Okay.
See.
So on me, I gave you 10-1 and 10-3.
This definition says where a product or article is sold, dispensed, served, or provided with the knowledge, actual or implied, that the product will be or is intended to be mixed or combined with an alcoholic beverage. Actual or implied. Okay, in any event, all right. Mr. Lambert, what is the tenant respondent's response?
Judge, if you'll just indulge me. The last time we were here, there was an argument about spoliation. And there were 6 criminal cases that were ancillary to the proceeding that was here.
Okay.
As the court's well aware with the clerk's office, there are files that are generated as a result of that. In all of those cases, a spoliation motion was filed. The state conceded it. This is back in April, May. I was looking for something from that file, or those files, and I went to the clerk's office, and all those public records are gone. They're nowhere to be found. The names aren't even there. It's as if they never existed. My concern here is that the same thing will happen with, here you're imposing a fine. Over there, they can impose a fine plus restrict liberty. But what seems to happen is when it gets down to the point of being able to criticize it or to evaluate it, everything goes away. So I have nothing to argue for today. All I have is what occurred in the past that I fear will occur in the future with regard to this. And there are criminal cases that are pending as a result of this.
Okay. Well, as far as this particular proceeding today is concerned, we have the 2 violations that are spelled out in black and white. This is an administrative proceeding. We don't have a burden of proof to the exclusion of all reasonable doubt. And we don't have formal rules of evidence here. And it is an administrative proceeding convened for the purpose of addressing alleged misconduct that rises to the violation of the city ordinance by a business. We have heard direct testimony from the investigating officer. We have seen the video. We have heard the commentary of the participants. There was definitely alcohol being discussed. There was definitely alcohol being implied. And we have direct evidence that this activity all took place at 1:30 in the morning. So that having been said, I find the tenant respondent in non-compliance. Okay. Now that I have found the tenant respondent in non-compliance, what is the relief the city is looking for?
Mr. Magistrate, we asked you again today that you determine that these violations are irreparable and irreversible in nature. At the time that they occurred, the benefits of the violation happened at that time and can't be reversed. The advantages over the other businesses, the risk to the community of alcohol being consumed and served in an area that's would put people out in the streets at after hours are general concerns. The conduct is the gravity of the conduct is egregious. We've been over this since June of last year. We've have prior violations. This is something that's reoccurring over and over again. And so we believe that the maximum fine is reasonable and appropriate. You have prior testimony of other businesses that have been complaining that are not able to exercise these benefits that are being utilized and exercised by the respondent. As it relates to the owner of the business as well, You put the owner of the business on notice. She had been given an opportunity. You waived some of her earlier delays, accepting in the past her efforts to get counsel and to try and figure out what she wanted to do. She had a reduced or relatively balanced minimum on her initial violation of not moving forward to take some legitimate good faith effort to remedy or exercise her authority or power against what was going on in the business. She represented that she was going to, and through her counsel, that she was doing evictions. She voluntarily dismissed her evictions on whatever her reasoning or the reasoning that she felt she believed from counsel, but nevertheless was voluntary. She continues to receive rent on the properties. And as prior testimony, this is a lease that should have been well terminated, expired, and now it's either going month to month or being authorized. But in any sense, this respondent, the owner of the property, has failed to take the actions that she promised she would take. She failed to show the diligence. She's never expressed or suggested she's come down and taken any specific effort on her own. The application of this was through her agents, which would have been those who were utilizing the business. So she was well aware of what is going on, what has been going on, and hasn't taken adequate effort to resolve it. We would ask for that to be, again, in the same finding, irreparable, reversible, and $15,000 fine to be imposed.
So what is the total amount of the fine the city is requesting from the owner of the property?
Well, actually, with the owner of the property, we have 2 violations that she could have taken better effort to try and prohibit. One was the sale of alcohol. The second was to ensure that nothing was going on after hours with this sale, or ensure that the business that she allowed in her facility had the licensing and the state requirements. So with it being 2 violations, the real request would be that she be found in violation of both counts 1 and 2, one being not having the allowing this business to operate without a alcohol license, and 2, allowing this business to operate after hours.
So you're suggesting that the owner could theoretically be on the hook for a $30,000 fine?
Yes, sir.
And you get to a multiple of 2 by doing what? Because there are 2 violations?
Yes, it would be like a 2-count petition.
Okay, well, I am not opposed to the consideration of multiple penalties, but I think I would predicate it more on the fact that there were multiple events as opposed to breaking it into subcharges. All right. Ms. Tran,
Yes, sir.
city wants me to fine you $30,000. Their contention is that this violation is something that you started to remedy and then voluntarily chose to stop. Presumably, as a result, the misconduct continued, and here we are again. And now I'm being asked to fine you $30,000, and I suspect I'm being asked to fine the tenant $30,000 as well. So, and the contention being made by the city is that the violation is, what is it?
Irreparable, irreversible in nature.
Irreparable and irreversible. So I guess the first question is whether you consider the violation to be irreparable and irreversible. And then the next question is whether or not that $30,000, in your humble opinion, would qualify as something to be considered punitive, above and beyond what the circumstances may call for. So that having been said, I'm only explaining this now because you don't have Mr. Vagovic here anymore. So having explained that, what say you to the city's suggestion that I should be fining you $30,000?
Mr. Magistrate, my English is not that well, so I understand probably 70% of what is going on. But on the side of the landlord, I did all my best. When Mr. Vagovic, on the day of the trial to do eviction, Mr. Vagovic called me and advised me. He is my attorney. When he advised me to stop this because it's not benefit me, because the previous case has been dismissed by magistrate here that they don't have enough evidence. So when we go on the trial, he advised me this is not the best solution. So I have to stop that trial. I'm not happy with the solution, but I have to because he is my attorney. When he told me not great, I have to follow. So I don't I don't see why I have to pay this 30,000. To be honest, I'm only the landlord and I do my best. I did my best. I did the process. It's just the attorney advised me that what can I do?
Okay, I guess all the same questions now are presented to the tenant. Let's say Mr. Lambert, as far as the $30,000 fine that's been requested.
Judge, I do think it's punitive. Again, the city is asking for it, I'm assuming, based on prior cases, like a historical. We need it here, but certainly if this were the one and only event, those considerations wouldn't be proposed to the court. So I think they are referencing old events to reach a request for this amount.
And I'd like to respond to both, if I may, Ms. McKelvin.
Sure.
First, as to Ms. Tan. Also, we had mentioned several documents, and one that I don't know if it ever reached you was that there was an agreed order to release funds in the clerk registry where she was with this voluntary dismissal also obtained $24,000 in funds. So I'm not quite sure how much effort was really being made to move forward.
Can you
I'll
start
pro-
over? I didn't
Yes,
understand what you were saying.
I'll present to you an agreed order to release funds in the clerk's registry as part of what their agreement as they closed the case, the rental case. If I could present that to you.
Sure.
And my point there is just that, again, this is the measure of these violations as we start asking the question of punitive, whether the punitive or not is still statutory, looking at the gravity of
What
the.
is this $16,451.57? What is that number? How was that arrived at?
You're asking me?
Yeah.
This would have
No.
been, I'm sorry, I don't know how it was arrived at. This is from the proceedings between Ms. Tan and the business.
Judge, I can tell you what it was. Social Daytona every month was putting rent into the registry of the court.
So how many months of rent is this?
7.
Pardon?
Coming in. 7.
Sorry, can I give you information?
Sure.
Is 6 months of rent and the insurance and the property tax for last year 2023. And I didn't know the case dismissed when the trial dismissed Mr. Vagovic is not clear enough to let me know that's mean the eviction has dropped. Until I hired Mr. Slick Michael, and he told me that the case is already dropped and you have the fund in there that you didn't even aware of. I didn't aware of that fund was in there. So he told me that now I have to help you get that fund out. So he did. If you can see the case is I didn't aware of the eviction drop until like I think last month is when Mr. Slick come in and withdraw that money out from the court for me.
As I continue related to the significance of the fines being imposed and requested, the statutory provision as well as our code provision for determination of fine amounts is one, to look at the gravity of the violation, two, the effort of the respondent in curing that violation, and three, the history of the respondent related to violations, and particularly these types of violations. In this case, there's heavy evidence of one, it being the gravity of it is it's just impacting an area significantly and the related businesses around it. The effort of the respondent, you've given much opportunity for the respondent to cease and move forward to aid in getting this conduct to stop. And of course, we look at the history where this, in fact, the respondent is actually benefiting in some ways. But
Has the last $15,000 fine been paid?
That's the one that's being appealed, Judge.
I'm sorry, what did you say? That's one been contested?
Yes, the last one that he
Oh,
imposed.
yes, I agree with that.
You agree with what?
No, you were saying that the last 15,000 is the one that's the subject of appeal for the business.
And how long were our undercover officers actually on site? About half an hour? 45 minutes, something like that?
At the very least, at least based on the
So
the
they pay
video.
100 to 150 bucks to get through the door. They go inside, they buy alcohol. They're gone 30 to 45 minutes later. And this interlude starts at 1:30 a.m. Okay. I find the violation to be irreparable and irreversible. I find that we have two events that we're dealing with here. I find that the owner, we had previously taken into consideration, was in the process of evicting the tenant. The owner then voluntarily stopped those eviction proceedings. In hindsight, the owner might have been better off had they just gone forward in the lost, as far as I'm concerned, than voluntarily discontinuing it and collecting $16,461 in back rent along the way. So I'm fining the owner the sum of $15,000. I'm fining the tenant respondents the sum of $30,000. I find that the violations were irreparable and irreversible. And I find that they were plenty egregious. And I have given a little bit of consideration to the owner in not charging her $30,000. But I will suggest to the owner that if we find ourselves here again and no eviction proceedings have been, well, without the owner taking whatever remedies are available to the owner to try to rectify this situation, then the owner can expect the full amount of the fine the next time we're here. Is that all I need to do?
That's everything we have today.
Do you want to say anything else before I adjourn?
I have nothing further.
Do you want to say anything else before I adjourn?
No, sir.
Okay. So then, so I can be perfectly clear, I'm finding the owner respondent the sum of $15,000. I found both respondents in non-compliance. I'm finding the owner respondent the sum of $15,000. I'm finding the tenant respondents the sum of $30,000. Very good.
Magistrate, sorry, I don't feel it's fair because I have done my best, and this is
No,
not.
you haven't done your best.
You can ask Mr. Vakovic, is he not want to go into the trial? And he say it's
You
gonna
need to
lose.
take that up with Mr. Vagovic and Mr. Slick. I can't tell you what to do. I can't tell you who to hire. I can't tell you how to do it. All I can tell you is we're dealing with the same violations that I previously only fined you $500 per event for, because you assured me you were going forward with the eviction proceedings, which satisfied me that you were doing everything you could to rectify the situation, and then you stopped it.
It wasn't me who stopped. You don't know how much money I have put in to hire and pay for Mr. Vakovic and Mr. Slick. And here, Mr. Slick also told me is not the right way to do that, because since the case dropped, it wasn't me who doesn't want to go in the trial. I was there. Mr. Vakovic have to call and say, if this loss is mean that you have to pay for their, and they don't have enough evidence. It wasn't me who don't want to evict. Is you have dismissed the case because it doesn't have enough evidence. And now I don't see why it have to be on me when you dismiss the case that doesn't have enough evidence. How can I evict the tenant if the case already dropped? What reason I'm gonna evict the tenant? That's what Mr. Vakovic told me.
Okay, well, I'm not here to pass judgment on the merits of Mr. Vagovic's efforts. You can take that up with Mr. Slick. You're the property owner. The city of Daytona Beach is dealing with this situation while you're wherever it is you are. You are trying to deal with this through various agents, whether they're good, bad, or indifferent. You're the property owner. You're responsible. The city of Daytona Beach is continuing to endure these circumstances. So all I can tell you is fix it or be fined again. Good luck to you. We're adjourned.